Hello, everyone. First and foremost, I would like to acknowledge that we are holding this virtual session from multiple Indigenous territories which have never been ceded. For our colleague in Quebec City, this is the traditional territory of the Innu Nation of Quebec, the Nitasignan, as well as the treaty lands of the Huron-Wendat Nation, Niuansio. For those in Montreal, we recognize the Kanahaga Nation as the custodians of the land and the water on which we are gathered today. Beyond this verbal recognition, I would like to invite us all to take daily actions in solidarity with all Indigenous peoples of this land. My name is Amel Zaza. I am the co-founder and director of the Migrant Justice Observatory, an independent, non-profit organization founded just over a year ago by individuals with immigrant backgrounds who work in various academic and civil society sectors in Quebec. The observatory's mission revolves around research mobilization and knowledge dissemination from a critical perspective to support a vision of a more just society for immigrants and migrants and improve access to their rights. So today is the second information session that is for international students. We have seen in the past couple of months many measures that impact them directly and members of their family. We noticed that many people express difficulty in understanding these measures, and so we decided to organize, in collaboration with our partners, this information session to help people better navigate these changes. So the session is pretty intense, so don't worry if you don't catch everything. We will make it available afterwards on our YouTube channel, so you can watch it again and you can share it with people who could not be here to watch it today. So I will pass it along to Senur, who is a researcher with the observatory and who helped with the organization of this session, and who will explain the context in which we developed this session and to introduce our participants as well as the partners who helped develop the content. Thank you, Amel, and hello everyone. Welcome to this information session for international students. It is my pleasure to welcome you. And as Amel said, my name is Senor Oxlin, and I'm a researcher at the Migrant Justice Observatory. Just to let you know, this session will be available in English in a couple of days. We'll let you know. As Amel said, we have witnessed an increasingly hostile political climate towards immigrants, and all these measures that have been announced that concern specifically international students, both at the federal level and at the provincial level. And it is this context we decided with our partners to organize this session, especially since we know how limited free legal resources on immigration, how rare they are, and how difficult to access they are, and at what point it is difficult to navigate the immigration system. Just to give a word on our partners who helped with the preparation of organizing this session, we have La Clinique Solution Juste, La Clinique pour la Justice Migrante, and the Immigrants Worker Center, IWC. So we're going to have three immigration experts who will be speaking to you, and I will have the pleasure of introducing them in just a moment. Just to explain, given the wide range of measures and all the details involved, we really wanted to give each speaker enough time to explain these changes and what these changes will mean. So we're talking about the options for renewing a permit, staying in Canada after graduate, and among other things. So for this reason, we won't actually have a question and answer session at the end of the presentation, but you're welcome to ask questions and share your thoughts in the chat throughout the session. So allow me to introduce the people who are going to be with us today. We have Claudine Boucher, who has been working as a constituency assistant specializing in immigration in the riding of Louis Herbert in Quebec since 2017. So in this role, she's She supports individuals of all statuses with various immigration-related administrative processes. Cho Ki-yoon is our next speaker, and he's been involved with the Immigrant Workers Center since 2015 and actually currently serves as the chair of its board of directors of the center. He is also an assistant professor at the School of Social Communication at St. Paul University, where his research focuses on immigration policies, the working and living conditions of migrant workers, and their collective action. And finally, we're pleased to have Camille Bonenfant with us today. For over a decade, she's been involved in migrant support networks. And Camille today continues her commitment to defending migrant rights as a coordinator and community organizer at the Migrant Justice Clinic in Montreal. Before handing it over to our speakers, I'd like to highlight two important points. First, the information presented today in this webinar is general in nature and does not constitute legal advice. Only members of the bar or of a regulated professional order can provide legal advice tailored to your specific situation. So if you have particular questions, we recommend consulting a lawyer or a qualified legal professional. Second, please keep in mind that the information discussed today may no longer be up to date in a few weeks or months. It's therefore crucial to regularly check official government websites, such as IRCC or MIFI, to ensure that you have the most current information. So I will pass it on to my colleague Claudine, who will start. Voilà. Thank you. Hello, and thank you for inviting me to participate in this information session. First, I want to return to the point that has already been made about legal advice, because here at the riding office, sometimes there's it comes up a lot, and sometimes there's some confusion. The work we do at the riding office is not legal advice. We do not do legal work. Our role is to act as a bridge between federal institutions and the people, I'm not going to say citizens, but people who are on the Canadian territory and who are subject to these institutions by way of their presence on the territory. So our role is to serve as an intermediary rather than an advisor. So that guides our interventions and how we deal with all the requests that we receive at the office. So talking in particular about the changes that were made to the programs that impacts international students, which is at the provincial level and the federal level. So we're going to discuss the impacts that lowering the caps will have on students. So it is certain that this is a major change that was announced last fall, both at the federal and the provincial level. And it's certain that the reduction in caps, the lowering of number of places available, will have a major impact on all actors involved, as much for the students as the actual educational institutions. So when we look at the legal project, the Bill 74 adopted by the National Assembly last November, we're talking about reducing, so when we're talking about Law 74, what it allows the Quebec government to control by sector, by field of study, by geographic region, by program, by type of program. It allows the government to put maximums on whatever category of immigration. So it gives the power to intervene specifically when it comes to the number of students admitted on the basis of what specific program to what place. So if you want to get the bigger picture, think about the fact that we talk about the regionalization of immigration. It's like this dream that, the government is going to be able to prevent people from settling in big cities, and that we can push them to allow them to settle more in the regions, even though we know that there are educational institutions in the regions like CEGEPs, which depend heavily on enrollment from international students. So we can see a little bit of what they're trying to set up here. When we talk about impacts, they're already apparent. And I mean, these have already been mentioned by the heads of schools who made representations in this file. We're talking about a 20% reduction in enrollment from international students, which is huge. The tightening of many criteria, like the financial criteria. This we see with a lot of people who come to our offices, people who are already studying, who are already here on the territory, who were admissible but are no longer admissible because they can no longer meet the criteria for available funds that they have to show. So these are changes that you can't quantify. What you can quantify is the amount of people who would have been admissible but are now not. So people who are not yet in the territory, who haven't arrived yet. Well, so we can't exactly say, but we can guess that the tightening of the criteria, there are probably a good portion of students who will not apply now because they're not admissible. Another aspect of these changes that has had an impact on the number of admissions. So the number of people who can come and study in Canada is the issue of spouses and partners, because before, regardless of the program of study, you could ask for an open work permit for your spouse, and there was no restrictions, or practically none. However, there's been a major change federally that has imposed a restriction, so that now it's only students who are doing master's and doctoral students that can have access to an open work permit for their spouse. So de facto, all other programs are excluded. So from memory, because I haven't had time to verify, but there are some exceptions. There are a couple of programs they're not our graduate or doctoral level that still give admissibility. If I recall correctly, it's people who are studying, let's say, in healthcare. Even if it's not at the second or third level, you can still ask for an open work permit for their spouse or partner. So there are some exceptions, but it's very, very restricted. Also, all of these restrictions apply, like when we're talking about program of study to open work permits to financial capacity, all of these new restrictions apply to everyone. There's no acquired rights. So as I mentioned before, there are students who were like admissible before who came to study and now all of a sudden are no longer admissible. There's a measure specifically for individuals who were before able to get a work permit as a spouse, who would technically no longer be admissible. Those are the only people that have like a sort of acquired rights. There's a possibility for those people who already had a work permit, they will not cancel those work permits that were issued. So those people have been given like a little bit of breathing room. But otherwise, the new criteria applies to everyone. Also, we can talk about the new limit of 24 hours of work off campus. So again, like we're talking specifically about work that's performed off campus. So we went from 24 hours and that was actually reduced to 20 hours, but now it's come back to 24 hours. So that's a return to what we had before. Work on campus, there's no limit on hours for the work that's performed on campus. So this is like still good news because we allow people to have more hours. So they're able to support themselves financially. And while we're on the matter of money, the increase for tuition that was put in place for international students, so like from what date was that effective? So that's been in place since fall 2024. So since the fall semester, which has just happened. So that's when that measure came into effect. And as it concerns the post-graduation work permit, which has also been impacted by the most recent reforms, in effect, the post-graduation work permit, the only admissibility criteria is the number of hours of the program of study. So basically, when we are verifying admissibility, someone who did a program of study that's 900 hours or less, so we're talking about like 8 months. So 900 hours or less, most of those people will not be admissible for a post-graduation work permit. However, there is a lot of exceptions. It's actually pretty difficult. We can't just go to the IRCC website to verify whether you're admissible. You're gonna have to dig a little more because while the general rule says 900 hours or less, there are exceptions depending on the sector. Also, all undergraduate, master's, or doctoral programs are admissible for post-graduation work permits. For all the others, so everything that's like college level, professional, shorter programs, like certificates, that's going to depend on the field of study. So certain fields of study that were identified as of being a priority for a need of labor. So we're talking about agriculture, agri-food. Actually, I can list all of them because the list is so short. Agriculture, agri-food, science, technology, engineering, and mathematics, education, healthcare, trade, early childhood, and transport. So those are the fields of study for programs that are outside of a bachelor's degree, master's degree, or doctoral degree. So you have to have studied in those fields of study in order to access the postgraduate work permit. And when we're talking about the language requirement for these applications, you must be able to show competencies in one of the official languages, either French or English. You don't need both languages. It's really one or the other. So you are required to show proof by way of an official language test to be able to apply for a postgraduate work permit. I hope this helps answer some questions that have been raised. And voila. Thank you. Thank you, Claudine. Yes, that helps. Like you said, there are so many exceptions, as you mentioned, to every rule. It's very, very complicated. So I have shared links in the chat so people can go and check the websites in order to verify. So I think that's pretty complete because it's very complex for the time, and of course, Cholki, if during your part, if you see there are some things to talk about or you want to add details, don't hesitate. So I'm gonna pass it on to Cholki, and thank you, Claudine. Thank you, Claudine, and thank you, Sindel. So I'll start by adding some information about what has been already talked about. So as it concerns the caps for immigration, there has been a reduction for admissions for international students already for the federal government last year. In 2024, the federal government announced a reduction in the number of study permits of 35% for all of Canada compared to the 2023 numbers. So already that was a considerable reduction that has already occurred. So then the federal government announced another reduction of 10% for 2025 and 2026 compared to previous years, which is compared to previous years for 2024. So the numbers for 2024 were already reduced by 35% compared to 2023. Also, as mentioned, the federal government reduction was for all of Canada, but it was not the same for every province. It was actually a function of the population of each province, so the number of people in each province. So the most impacted province was Ontario because of its portion of the population. And then also Quebec was also really affected. So the recent announcements concerning reductions of the limits by the Quebec government adds to this situation because it applies to the number of the year before, but the year before was already a reduced number. So to reduce that number by 20% is more extreme than the one that was announced by the federal government. Also, the distribution of this reduction, so we're talking about quotas, is not the same for every educational institution. So we saw with the adoption of Bill 74 that Claudine explained, this allows the Quebec government to impose different ceilings depending on the program or the school. And we saw that Quebec has already started using the measure to impose these limits. So 20% reduction for all of Quebec, but then we are seeing programs at the college level being more impacted. But this quota also applies for master's and doctoral programs. And it's the same for the measures from the federal government. The reduction of 2024 applied only to undergraduate programs, but in starting in 2025, it will also apply to master's and doctoral programs. So it's important to note that these programs will be impacted, and for every educational institution, the number of international students admissions will be limited. This will mean there'll have to be a distribution internally done, which puts another administrative burden on schools. What is even more complicated, Cholky, sorry, I'm going to take the opportunity of you coughing to ask a question, just to be like certain for the international students who are listening, to make sure they understand. We're talking about caps. Can you confirm that when we talk about caps and we talk about these reductions, like take me for example, I'm an international student who has already started my program. So whether we're talking about the federal level or Law 74 for Quebec, for each school, we're putting a limit on the number of admissions. As a student who's already started, will I be impacted by like when I want to renew, my study permit? Will these limits impact me? Maybe you can't answer because it's super complicated, but I just wanted to ask. Yes, in fact, for the federal announcement, these students were exempted, but for the Quebec announcement, honestly, I didn't check. I don't know if Claudine has the answer, if study permits are impacted by these caps. Look, I don't have a clear answer. Going through the documents from Quebec, it wasn't written anywhere that there'll be acquired rights for students who are already here. And I think that this signals that in practice, they're going to give. So since they give the responsibility to educational institutions to make the choice when it comes to who they accept or who they don't, so I'm guessing that it will be the education institutions that will take the decision, in the sense that they're going to be given a number, and then the school has to figure out how it's going to reach that number. And how they choose to do that will belong to them, if my understanding is correct. The educational institutions, I think they should be conscious that they shouldn't reject people who are already there, because that would be chaos. But in any case, I had the same question when I was doing my own research for the presentation. I have to say, I did not find a satisfactory, a good answer. So I also have the same impression. I wasn't able to find a precision on that aspect, which would lend the impression that the people are included in the quota and that each school has to manage them as a function of that quota. And what is more complicated is that it's not like the admissions, but any extensions. So in particular, doctoral students, they often have to renew their study permit 2 or 3 times. Also, we have to think about exchange students. So exchange students that come for more than 6 months, they have to get a study permit, and therefore will be included in the quota. So each school is going to have to establish their own criteria of how they're in this matter. Also, so the Quebec announcement was only done to cover 1 year. The reason is that the Quebec government expects an announcement of caps for immigration. So we have the one that happened in 2023 for 2026, but there will be another consultation this spring, so another announcement maybe in June for the upcoming years. And in this announcement, temporary immigration, including international students and temporary foreign workers, they will be included. So there will be ceilings for those categories. So the quota, so the reduction that was announced, that was just one time. And for the upcoming years, it will be based on the caps that will be announced later on. So at this moment, we don't know how much the caps will be reduced, whether they will be maintained. We'll be finding that out later. So there we go. That deals with the matters of limits or caps for immigration. When it comes to family accompaniment, so Claudine explained the new restrictions for open work permits for family members, so for spouses and partners. Also, before, dependent children were also able to get a permit, but that's no longer possible. Now it is only spouses and partners that can get work permits, and there are various restrictions that were added to that. Especially for master's students, the master's degree has to be more than 16 months. So it's not all master's programs that are going to be admissible for the open work permit for spouses and partners. For different fields of studies, there are some exceptions, in particular for healthcare, but also for bachelors in education or engineering. So it's really necessary to verify the list. So you have to go to the Government of Canada website. So that's that for family accompaniment. But of course, that does not mean that, people, they can't come, but rather they can't come as spouses of a student with an open work permit. But they can come in different ways. They can come as a visitor. Of course, dependent children and spouses and partners can still get their own work permit or their own study permit, which would allow them to come. But obviously, it was much, much easier to come as family members, and now it's become way more complicated. Now, for the matter of the post-graduation work permit, just to add some information, to start with the language requirements, which did not exist before. So before it was really your degree that mattered, but now there is this new language requirement. So for university studies, that's a level 7. So it's an intermediate advanced level, 7 out of 12 levels. Without a doubt, that's a pretty high level, and in 4 categories, which is listening, speaking, reading, and writing. So a minimum of 7 in those categories. And for cégep or college degrees, or other types of degrees, the requirement is a level 5, again in the 4 categories. So this is a different criteria. So in all cases, this language competency requirement applies to all international students already here, but also a function of their program of study. But for students that submitted an application for their permit before January 21, 2025, they are exempted from the restrictions based on field of study. Before Claudine, she specified certain fields of study. More specifically, however, the number of specific programs included in these fields of studies, that list is actually very, very long, and we can't go through all of them here. You have to go check the government website. Now I want to talk about access to permanent residency. So, we know a lot of students come here with the dream of settling permanently in Canada or in Quebec. And also, for a very long time, international students have been considered the ideal immigration candidates. However, with all the debates around immigration, around temporary immigration, we are unfortunately seeing various restrictions being imposed. So as you probably already know, if you are in Quebec and you want to settle in Quebec, in this case, Quebec has its own criterias and its own programs for economic immigration. And among these different programs for the economic immigration category, there are two programs that are very popular or important. So that's the Quebec Experience Program and also the regular skilled worker program. But for the second one, the regular skilled worker program, it was actually supposed to be renamed the Qualified Worker Selection Program. And there were going to be changes with all the criteria and everything, which was supposed to apply as of the 23rd November 2025, if I'm not wrong. But the government announced at the end of October, I believe, a freeze for the two programs. So for the regular program and as well as for the graduate stream of the Quebec Experience Program. The stream for workers is still open. So the two programs are temporarily closed until the end of June 2025. So we made a new program to replace the regular skilled worker program, the Qualified Worker Selection Program, but it isn't active to this day. And we don't know if the government will modify it further. So right now, we really don't know, and we're going to have to wait and see. So I think we need to talk about the graduate stream of the Quebec Experience Program because it was a really significant program for international students who got their degrees in Quebec to allow them to stay in Quebec. And it was a really important program for these graduates. But just until the end of June, your application would not be processed. And after it opens, we don't know if there'll be further changes. But I want to explain to you some of the important conditions. To start, you have to have an intention to reside in Quebec, so you have to show that you plan to stay in Quebec. And also, evidently, the most important criteria is your degree, which needs to be obtained in Quebec in the 36 months preceding your application. And of course, there are the language requirements. So there's two aspects to this language requirement. For language requirements, you have to show a level 7. So again, intermediate advanced for speaking, but so level 7 for speaking, but level 5 for writing. So that's different depending on the field. So if you want to add your spouse to the application for permanent residency, your spouse also needs to have a competency in French at a level 4. Since 2019, there have been a lot of changes to this program, and the requirement for spouses is another requirement that has been added. So if you obtained a level 7 in French, so on your language test, it's not enough. There's also a condition that's related to your program of studies. You have to have completed a program in French. So that's an important condition. So if you got a degree from a school or from a program that's given in French, so more precisely, the credits you complete, 75% of them have to be in French. For thesis and dissertations may be completed in a language other than French. However, the 75% threshold must be met for other courses or credits. And if not, you have to have at least completed 3 years of full-time secondary or post-secondary studies in French in Quebec or abroad. So even if you get like level 7, but you did your degree in English, but even in your home country, you did 3 years of secondary education back home in French, then you would be admissible. But if that's not the case, even if you have a level 7, your admissibility is limited. So those are some of the conditions for the Quebec Experience Program. So how to stay in Canada after your studies. So we already talked about the post-graduation work permit, which you have to apply for within 180 days of confirmation that you have completed your program of study. So this hopefully will cover the time before you get permanent residency. So, but if that's not the case, because this type of work permit is not renewable except in like very exceptional circumstances, which we won't discuss them. It's the government will tell you if there's an exception, but it's just very rare to be able to get a renewal. So if you haven't obtained permanent residency or your certificate of selection from Quebec, which is a document you get before getting permanent residency, you would have to get another work permit to maintain your status. And I mean, of course, you can always stay as a visitor, but that's not very stable and it doesn't allow you to work or study. So in most cases, if you want to keep working, you're going to have to get another work permit. And in most cases, that means a closed work permit through the temporary foreign worker program. So if you don't obtain your CSQ before the expiration of your post-graduation work permit, you need to prepare an application for the closed work permit before your expiration of your post-graduation work permit. So however, if you have applied for your Certificat of Sélection de Québec, luckily, in these cases, you actually might have access to a work permit. But like from the moment you obtain your CSQ, you can obtain a work permit, but like not through the temporary foreign worker program, but rather through the International Mobility Program, which we often call an A73, which is the name of the form that you would fill out. It is a closed work permit, but without an LMIA and without a CAQ. So it's based rather on your CSQ, which allows you to apply directly to the federal government. Now, obviously, there are a couple of things that the employer is going to have to do. So the employer will have to give a valid job offer, and that's going to have to be registered on the employer portal with the federal government. But the LMIA is not required, and so the processing is much, much faster. So if you've obtained a CSQ and your post-graduation work permit is soon expiring, it would be a good idea to get things in order to get yourself an A73 work permit. Also, so many people who have like obtained a CSQ will ask if they can get a transitional open work permit because they don't want to return on a closed work permit. And in principle, yes. But it's not upon receiving your CSQ, but rather, it's complicated. In principle, what you have to do is you have to submit your application at the federal level for PR. Then you will get a confirmation of reception, but that's not enough. But in because what is required is that your application has to have undergone exhaustive review. So the government doesn't usually really actually tell you you're admissible, but rather you have to ask the government about the status of your file. But usually, general rule, it's when they ask you for your medical examination. That's when you become eligible for the transitional open work permit. But the problem is that exhaustive review of your application, if it's been done, that means your file was opened and general verifications have been done. So it doesn't mean you've been selected, but it confirms that you've submitted all the documents, and this review can take many, many months. So what happens is it's only at the couple months before you are actually given permanent residency that you become eligible for the open work permit. So it's not actually very useful, the transitional open work permit for holders of CSQs. And so that's why in most cases we see people are going for the A73 closed work permit. So that was just a quick look, because another thing is we see more and more international students who are struggling to pay their tuition fees and have started working. And as Claudine explained, there's a limit of 24 hours a week. Now, during studies, during breaks and vacations, there's no limit. But during studies, there's a limit. And full-time employment is 30 hours. So it makes it hard to cover living expenses and also tuition fees. So international, especially for international students, fees have been raised. And for this reason, we are seeing more and more students that have decided to leave their studies and to take full-time employment on a closed work permit, and abandon their student status to become a temporary foreign worker. And then this is often done at the request of their employer or the recruiter. But you have to be careful, because we've seen people who get fired and this causes them to lose their status. And then at that moment, it's not really easy to return to studying. So this is very concerning. And for this reason, and I understand very well, I myself came as an international student. I faced these difficulties. But regardless, all the difficulties, it's really necessary to find alternative resources that will allow you to keep your status as a student, especially if you have plans to settle long term and you want to access permanent residency using one of the programs we have discussed. So unless you have a job that is qualified, stable, and secure, it is a lot easier. Well, look, easier is a relative term, but it is relatively easier to get permanent residency as a graduate. So if you are having financial difficulties, you should contact your educational institution and see if there's financial assistance available, or bursaries, or loans. If you can stay in school, it's generally more advantageous And, most importantly, don't trust what the recruiters tell you, because for them, getting another person on a work permit is profit. So you have to be careful when it comes to trusting recruiters. And also, in the case, if you have health problems or family responsibilities, remember, you always have the right to request a leave, a break of up to a maximum of 150 days. So, instead of abandoning your studies, you can use this right to leave for health issues, family, to take care of your family responsibilities. And there's even other situations that might be allowed by your school. So if you have an emergency, contact your school, and it is always better to get an official leave, because afterwards that allows you to come back with your study permit. And finally, if you have lost your status as a student, this is an important element. The loss of status, the expiration of your status, is different for students compared to temporary foreign workers. So for the case of a temporary foreign worker, your status is valid until the expiration date that's indicated on your work permit. But for that's not the case for international students. If you have left your studies after the end of the last period of registration, you have the right to remain in Canada for 90 days. But beyond this period, even if there's still time remaining before the expiration date indicated on the study permit, your status is no longer valid. So you really have to be careful. So if you have lost your status, there's a process to restore. So it's really important to do an application before expiration. And even if you don't get an answer, if you have sent in your application before expiration, it means your status is protected during the processing of your application in the case of a work or a study permit, but not in the case for the CAQ. So we have to really apply. You have to do the application for the permit with the federal government to benefit from maintained status. So this allows you to remain in Canada under the same conditions as your last permit. And if you miss this and then your permit does expire, you have 90 days to restore status. So to restore status, you actually have to do a request for restoration of status, which in principle allows you to restore your status to whatever it was, whatever your last status was before loss. So that means if you were holding a permit, you can restore your status as a student. And if you had a work permit, you can restore your status as a worker. But so that's the rule. But sometimes the government may accept to change your status to a visitor. But once visitor status is obtained, it's more difficult to get permits afterwards. So you got to be careful. And also, when we're talking about a restoration of status, it becomes complicated because you have to show that you are capable of returning to your status. So that means you have to take in the steps to also get a. So while you're doing the restoration of status, you have to take steps to get a new study permit or a work permit, which means you have to have your acceptance letter from the school, and you have to show that you have the intention of applying for a study permit. So it's not just asking for a restoration of your status, but that process has to be accompanied by a process to obtain a new study permit. And, after 90 days, it's very, very difficult. So I will stop here. And if there's any clarifications need, please let me know. Thank you, Shoki and Claudine. So yeah, it's dense. It's a lot of information, and I hope it's going to help with the people who are listening. And the last part, to give you some context, many people have said that since the announcements of all these measures, sometimes they get advice from like family members or for immigration consultants to think about other pathways to immigration, like asylum claims or applications for humanitarian grounds. So because we want to make information accessible to help you make informed decisions, we have asked Camille, who is the co-coordinator of the Migrant Justice Clinic, to give you an overview of what these statuses are, what the criteria is, and like what it consists of, so that you can better understand. And it's obviously a very short presentation, but we are going to be putting some links in the chat that would allow you to get more information if you want to learn more. But it is a very quick 20 minutes just to give you an introduction to the topic. So I'm going to pass it to Camille, and I'll be back for closing remarks. Hello, today I will speak about humanitarian immigration, so humanitarian pathways. I know for many people who have difficulty renewing their permits, like their work permit, they might wonder if it's possible to file a humanitarian immigration application, like an application for asylum, in order to have status in Canada. So today I will talk about two options: asylum claims and applications for permanent residency for humanitarian and compassionate grounds. So I will explain the process and some important information to keep in mind about the risks, and so you understand what the possible consequences of if you decide to take these options. To start, I will talk about the asylum claims and when to do it. What is an asylum claim? An asylum claim happens when there's a fear or a risk of persecution, a threat to the life, of cruel or unusual treatment in the country of origin to a person in your country of origin where you have citizenship. So if we look at immigration law in Canada for protection of refugees, there are two sections that outline the reasons. So I'll read them. Risk of being subjected to torture, threat to their life, or risk of cruel and unusual treatment or of punishment in the country or countries where they have citizenship. Or a person who has a well-founded fear of being persecuted based on their race, religion, nationality, membership in a particular social group, or political opinion. So we see that for an asylum claim, there must be like grounds, there must be basis, there has to be something, a reason. You cannot make an asylum claim without grounds. In Canada, it is the RPD, the Refugee and Protection Division of the IRB, the Immigration and Refugee Board, that reviews the claims. Important to remember that we can only do an asylum claim one time. So it's important that the application is well prepared if it's going to have a chance of being accepted. Credibility is at the core of an asylum claim. It's very important. Your credibility will be at play. The commissioner or the member reviewing your claim must find you credible. So 4 legal principles guide the assessment of a refugee claim. The first is your identity. So your identity, the prospective risk. This means that if you were to return to your country of origin tomorrow, the risks that you are alleging must still exist. It is important to demonstrate that these risks are ongoing and that they would exist if you return tomorrow, and that there was a risk that you would be persecuted or you would have a violence or to be tortured, and that those risks are real and they're not just in your past. they exist always today. The third principle is internal refugee. You must show that you are seeking protection in Canada because there are no safe options in your home country where you could find protection. For example, if you lived in the capital and a person then moved to another region and was able to be safe, and they're going to look whether those problems would follow them or whether the person would be able to live safely. So the fourth principle is state protection. So they're going to look at whether your home country's government can protect you. For many people, this protection does not exist, either because they belong to a particular social group and they are persecuted because they are a part of an ethnic minority group, and those are not protected, or because the country is so unstable that the government is unable to ensure the safety of its citizens. Now let's talk about the processes. An asylum claim can be made at a point of entry at the airport or our land border, but it can also be done from within Canada. So these are two ways to request asylum, but they start differently, but they're quite similar in how they proceed. So an asylum claim is actually made on the IRCC portal. On that portal, you have to answer a series of questions, as well as provide something called a BOC, a basis of claim. This is your story. What happened? You have to explain in concrete and precise terms the events that led you to require and request protection, to ask for the status of a protected person in Canada. Also, you have to provide evidence, and at the end of the process, there will be a hearing in front of a decision maker. It is a long process and can take between 1 to 3 years before you have a hearing. If the asylum claim is rejected, it's always possible to appeal the decision, and during the process, there's normally no removal to the country of origin. So that means you can't be sent back to your country of origin while you're appealing. So an asylum claim does give the possibility of an open work permit, and as well, it's also possible to access social assistance, so financial assistance, and medical coverage through the Interim Federal Health Program, which is a federal program. However, it is not possible to have a post-secondary education. Well, you can do them, but you will have to pay the same price as an international student. If the claim is accepted, the person is accorded the status of a protected person, but this is not permanent residency. So that after that, once you have a protected person status, you have to ask residency. If you're in Quebec, you have to ask for the CSQ, Certificat de Sélection du Québec. After that, you have to request permanent residency, and after many years, then you can apply for citizenship. So a couple things to remember about asylum claims. Unlike other immigration applications, you must sign, at the beginning, you must sign a conditional removal order, which means you accept to leave country as soon as possible after a refusal. So that's not, you don't have to do that in other immigration applications. But for an asylum claims, it's required. You have to sign it. So the border service will apply this order depending on their priority or as soon as possible. Another thing to remember is even though if the story is found credible, there can be a rejection on the basis of possibility of protection in the home country. Remember, I talked about the 4 principles that apply to the review of an asylum claims. So internal protection is that there are some countries like Mexico, Nigeria, or India where there are situations that can support an asylum claim, and there's no issue of credibility. but there is a determination that there are regions within the country that the person could go to and would have protection. The issue of credibility is at the core of the claim, and it can really impact, like the impact here is whether the decision maker who will review the claim will believe you at the hearing. And the issue of credibility can have longer term impacts. It can impact potentially other future immigration applications. A rejection of an asylum claim based on lack of credibility can serve to prejudice future immigration applications, leading to a more in-depth review of those applications. Another important thing when we are considering whether to do an asylum claim, when you are claiming asylum, it is not possible to return to your home country for sometimes like up to 10 years. When we make an asylum claim, we are taking refugee in Canada because the state of our home country cannot protect us, so we cannot return. So if we consider doing an asylum claim, you have to realize you cannot travel to your home country until you are a citizen of Canada. And that takes many years. So we're talking about 3 years for the asylum process, several months of waiting for Certificat Sélection de Québec. And of course, I'm talking about a situation where the person is accepted at the hearing. Obviously, if we add in rejection and then an appeal, that adds more time. But for somebody who's accepted right away, we're talking about 3 years to get to the hearing and then many months to obtain the CSQ. And then you're going to have several years before you get permanent residency. Right now, on IRCC's website for delays for processing, it is 47 months for someone to get permanent residency for a person with status of protected person, and that's for a person residing in Quebec. So 47 months, that's 3 years and 9 months. And then after that, you have to spend a certain amount of time as a permanent resident before you're eligible to apply for citizenship. So it's very important to remember that when you do an asylum claim, will prevent you from returning to your home country for many years. Another thing to remember is an asylum claim can be done at the same time as a spousal sponsorship application. So if you have a spouse that has Canadian citizenship, that person can actually sponsor you, and at the same time you can do an asylum claim from inside Canada. And to finish, I want to impress upon you that quality legal representation is very important to help you navigate this process, whether it's by a lawyer or immigration consultant. It's very important because these applications require a certain amount of skill, expertise, and it's not recommended to do a refugee claim or an asylum claim without representation. But of course, there is the issue of access to legal services. Of course, very much when we're talking about people who are looking for legal aid, lawyers. And at the moment, asylum claims that are done in private practice in Montreal, it's not it's normal to see costs about $4,500 for these claims. So I will talk about my second subject, which is a demand for permanent residency based on humanitarian grounds, which is different from asylum claim, even though people confuse the two. An application on humanitarian grounds is similar to what is called a subsidiary protection in other countries. It's a claim that's made within the country. It's very different from an asylum claim because we don't talk about prospective risks of persecution. Rather, we're looking at the situation, the circumstances in Canada. And it's the circumstances in Canada that matter. It's the integration of the person in Canada. and other circumstances that can also matter are the best interest of the child, if you have a child in Canada, difficulty to return to the country of origin, as well as issues with mental and physical health. So it's often an application that is done by people who have been here for a long time in Canada because they're able to show the level of their integration in Canada. So we're talking about work history, your volunteer history. It requires letters that will explain your relationships with friends, and to show that you are like anchored within a network or within a community in Canada, which makes the difference with this type of application. So when we're talking about asylum claims, you can't do both at the same time. What usually happens is you do an asylum claims and the person is refused, and they will do an appeal, and they will do all the processes possible when it comes that are available for an asylum claim. And then after that, they will try to stay in Canada by doing a humanitarian application. It's not required, but you cannot do both at the same time. Another aspect that is important also is that an application for permanent residency for humanitarian considerations does not suspend a removal order. Unlike what we were talking about with an asylum claim, where we cannot be removed to our country of origin during the asylum claim process, for an application for permanent residency for humanitarian considerations, on the other hand, does not suspend a removal order. So the border agency may still continue a removal process parallel to the review of an application for permanent residency for humanitarian reasons that Immigration Canada is doing. Another interesting thing, it is possible, contrary to an asylum claim, it's possible to reapply or a new application after being denied. It's always possible to do another application. Another thing to say about these types of applications is that they are discretionary. It is an immigration officer that will review the application, and it is really the opinion of the immigration officer that is the deciding factor. So you could have two applications that are similar in quality. One may be accepted while the other is rejected. Another form of information that circulates but is not true, but people tend to believe it, it's believed that if we have children and those children are citizens and they are born in Canada, that's going to help make sure our application is accepted. Unfortunately, this is not true. It's not because you have children and those children are born in Canada that means your application will be accepted. We are also talking about an approval rate that is very varied. So two statistics, in 2020 we had 43%, and 2023 we had 71% of applications were accepted. So it's very variable and it changes a lot. To talk about the process, what happens is you submit the application, and then there's a review, and then you get a response, which is the first step. So you'll have an accept or review. If you have an acceptance at this first step, that does not necessarily mean that you get permanent residency. This is just the first step. So it means that the request is accepted in principle. So the person doesn't have permanent residency, rather they have implied status, which can last for many, many years. So with that implied status, removal orders are cancelled, which is good news. There will be a possibility to renew open work permits. You're given access to a CSQ, which that opens up access to public medical assurance in Quebec, but it takes several months to get a CSQ. When we're talking about processing delays, it's very long. At the moment, processing delays for somebody who's residing in Quebec, it's 47 months. And that's not taking into consideration a backlog of cases. And as I mentioned before, that is 3 years and 9 months. This brings me to the subject of the caps on immigrations and how that impacts delays. Recently, immigration planning by the federal government that was done last fall, the plan came out for the years 2025, 2026, and 2027. We saw a significant decrease in the threshold or caps for permanent residency for humanitarian considerations. To give an example, in 2025, the limit is 10,000 applications. In 2026, it falls to 6,900. And for 2027, it falls again to 4,300, which is a very small number. So what this says is with the limit being lowered, it means that the people who are accepted in principle, who would have access to permanent residency, will not have access. This means that there will be many files that will take many years to be finalized. So people will remain just with accepted in principle, so with implied status. To summarize, at the core of the application is your integration into the Canadian society and Quebecois society. This is what needs to be the focus. Another thing to remember is the high cost of the application. We're talking about $1,210 in application fees, $175 per child, and $85 for the biometrics. And also, we must address the issue of legal representation. Again, very important here that a person has representation from a lawyer or an immigration consultant that is part of the regulated College of Immigration Consultants. Here, I would say it's even more difficult to find a lawyer that will take a legal aid mandate for this type of file. At the moment, we are seeing prices like $4,500 or even more for these types of claims in Montreal. So voila, I hope this helps answer some questions you have about the two processes, which are asylum claims and applications for humanitarian considerations, and that you can make a decision that is informed if you do decide to turn towards humanitarian immigration. Thank you, Cami, for the presentation, and to our co-animators of the session. So to finish the session, and I want to ask if you have any advice about what people should watch out for when they're getting legal advice, what they should be looking to verify, and if there's any free resources that international students can benefit from. Yes. So I can start. So to start, I would say it's always a good idea to contact your educational institution. Usually, large universities have internal resources that are with an immigration consultant or a lawyer that would be able to provide you with information. So it's always good to check with your school, but also there's a lot of smaller institutions that may not have this type of resources. So in these cases, it's more difficult. So if you want to look for a lawyer, obviously you verify the list of lawyers, but if you're not certain about a lawyer, you can consult the ACADI website, which is the Quebec Association for Immigration Lawyers. But of course, you might not be able to get a free consultation. But if you're looking for a lawyer, that's a trusted network. And when it comes to immigration consultants, there's also a list of immigration consultants that are registered. But what we are seeing is that while an immigration consultant might be regulated, they're not necessarily trustworthy. They might impose fees that are abusive. They might act in fraudulent ways. So you have to be careful. And it's always good to get a recommendation from someone you know. So like there's an organization, it's not a legal service, it doesn't offer legal services, but Le Québec c'est nous aussi. That's a network, and you can go check their Facebook page and can meet other international students in the same situation or who have already gone through the process. Now, the people that are the most risky are recruitment agents. So if you're trying to get a work permit, you can go to the CNSST website to see the list of recruitment agents that have a permit to operate, but that list is not a guarantee that that they have good practices. So even then, there are many recruitment agents that put illegal fees or that give bad information. So for recruitment agents, you have to be really, really careful. Also, it's important to note that regardless of your immigration status, whether you're a citizen or not, you can always go and find by using your postal code who is your deputy, provincial or federal, and then you can contact them for support. So, Claudine, if you can tell us a little bit more about that. Yes, of course. I mean, obviously, the services offered by your riding office can be variable because it depends really on your deputy. Not all deputies have put priority on the same level of services for immigration, but it's still a good idea always to check. So, like, if you've checked with your school and you've consulted the resources that are available and those were not enough or they didn't work, well, then in that moment, it's a good idea to go see your local deputy. I just also wanted to add something about something that was mentioned. It's very true that groups like Le Québec C'est Nous Aussi, they do a very good job and they can be a really good resource when it comes to finding information. But at the same time, and I have to say this, it's important to be careful when it comes to online discussion boards, that are not moderated or they're, between friends who are sharing their experiences. Yes, it's good. It can be a good resource for information that it could be useful, but there's also the risk of getting wrong information. And often, we see problems that come from relying on information from those places. So yeah, we can take information from friends and neighbors, but you have to verify that information. It's very important to double check the information, especially when it's coming from somebody's personal situation or experience. Thank you. Yes, you are correct. Everyone's situation is difficult and unique, and so you have to be careful. Yes, I do want to clarify something. When I mentioned Le Québec C'est Nous Aussi, it wasn't for the purpose of getting accompaniment, but rather it's a good place to get a recommendation for a trusted lawyer or an immigration consultant. It's more of as a way to be put in contact with a trusted legal professional. Similar to Claudine, I have also seen a lot of situations that were the result of bad information on discussion forums. So you are 100% right. It's very risky. Thank you. So it's a little bit for this reason that we've organized this information session, and I hope it was helpful. As Senor mentioned, it will be available, this session, in English on our YouTube channel, so you can rewatch it and you can share it with other people. So to finish, I just want to thank our partners, Clinique Solutions Juste, the Migrant Justice Clinic, and the Immigrant Workers Center, and Le Québec C'est Nous Aussi, that participated in organizing this session. So I wish you a very good night and see you again.